Good morning, everybody. My name is Karl Butterer. Thanks for your patience. Today, I'm going to be talking about the Fair Labor Standards Act and some related compliance issues. And I'm going to basically be covering four things, or breaking this into four issues today. One, I'm going to start with basically a refresher on the Fair Labor Standards Act, which I will just call the FLSA. Some of this is going to be kind of old hat for some of you, might be a refresher for others. For those of you new to the HR function, this will be a good starting point. Then I'm going to give what I call a weather report, which I'm going to give you some current FLSA conditions and a forecast, both at a national weather report and a local weather report. And I'm going to be torturing that metaphor later, so stay tuned. Then I'm going to talk about some common FLSA mistakes where we see cases arise. Some of these are easily avoidable, some not so much because it's kind of a tricky area of the law. And then finally, I'm going to talk about some hot topics, recent events, some very recent. And at that point, I'm going to hand it over to Tony, who's going to talk about some very important upcoming changes, or we anticipate changes regarding minimum wage and some related state paid sick time issues. So for our FLSA refresher, just to remind you, the FLSA, this is a federal law, and it generally requires that employers pay non-exempt employees, and that's a key term there, non-exempt employees. You have to pay them at least the minimum wage for all hours worked, and then you have to also pay an overtime premium for all hours that are worked in excess of 40 hours in a work week. The third basic requirement of the FLSA is it, as an employer, you have to keep basic records about pay rates, hours worked each day, hours worked in the work week, earnings per week. So these are really the three basic components of the FLSA that if you comply with these portions of the law, you're, for the most part, you're going to be, 90% of the way there. So when we're going to get into this a little bit later, but you noticed I said that the FLSA applies to non-exempt employees, okay? So for the FLSA to apply, they have to be an employee. This means that the FLSA does not apply to workers who are properly classified as independent contractors. Independent contractors are different naturally than employees. So again, just real quick, just so you know, that so the FLSA is enforced by the Federal Department of Labor. The state of Michigan has similar laws and a similar enforcement mechanism. And whether it's the federal government or whether it's the state government, the government can do an investigation and they can potentially start a lawsuit over those potential violations. And employees, even if the government decides that they don't have time or they're not interested enough, they could hand that case over to a private attorney, and then the employee themselves can pursue it without the Department of Labor or the state of Michigan essentially prosecuting that case for them. So there's some bad things that can happen if if the employer misclassifies the employee as an independent contractor. One, in fact, they should properly be classified as an employee. So here are the list of horribles. As an employer, you can potentially have to pay 3 years of back wages that were unpaid, either because you weren't paying minimum wage, or usually it's because you failed to pay overtime or you failed to pay for hours worked. We're going to get into that briefly in a moment. You can have to pay an equal amount in an additional penalty. So if you fail to pay $1,000 in wages, in overtime wages, not only are you paying that $1,000 back, but you're going to pay an additional $1,000 as a penalty. You are not only going to pay potentially your attorney fees, but the other side's attorney fees. And then if you misclassified someone as a independent contractor when in fact they were an employee, the IRS may come knocking, and because you will have probably failed to pay payroll taxes. So the IRS will come knocking and look for 100% of the employer's portion of FICA, a portion of the employee's FICA, plus a 3% penalty on top of that. The bad news doesn't end there. There's also the possible for criminal penalties for intentional violations. You don't see that a lot, but I think Cliff Hammond may mention this later if he gets to it. He's had some cases where, frankly, he may be concerned about some criminal penalties. So that is a consideration. And then to make matters worse, and I think this is very important, these FLA suits are not covered by your employment practices liability insurance policies. So lots of cases you're used to, things go badly. If it's a discrimination lawsuit, for example, you may hand that over to your carrier. You pay your whatever 15 grand or 25 grand self-insured retention or deductible, and then your carrier is taking care of the rest. Not so in FLSA cases. I've never run across a appellee policy that covers FLSA lawsuits. So, the employer in all likelihood is paying the freight, not your insurance company. So that is a matter of real concern. Okay, we're up for the National Weather Report, current conditions. So from the period of 2012 to 2020, that was a relatively high tide for federal FLSA lawsuits compared to prior periods. So during that, whatever it is, 9-year period, the cases that were filed in that period really outstripped anything that had been passed on a year-to-year basis in prior decades. So overall, the tide has been high from 2012 to 2020. Interestingly, though, when you look at the stats, and the federal courts publish these stats every year. I've taken a look at them. The DOL publishes some statistics too. But in 2022, this is the 7th year of decreased filings of FLSA lawsuits. But it's down about 35% from the high watermark of 2015. And it's the least since at least 2009, may go back even further. That's as far as I went with the statistics. And then the DOL, the Department of Labor, who enforces this law, they also report their enforcement of cases with violations. So not necessarily a lawsuit, but a suit that, or a claim that the DOL pursued. Those are down about 40% from the 2012 high water mark, and again, the lowest since 2009. So, the question is the FLSA tide of lawsuits and enforcement going to continue to ebb? And there's some reasons to believe that it's not. There's some really good reasons to believe that it's not going to continue to go down. In fact, it may go up. So in 2022, the Department of Labor added 100 new investigators. And for this year, the DOL is also poised to propose some new regulations that's going to make it more difficult to classify workers as independent contractors. And there's been some very recent developments in that we're going to get into. A few other developments. The Department of Labor is joining with other federal investigative arms and enforcement arms, including the Federal Trade Commission and the National Labor Relations Board. These are two different federal agencies that they do their own investigations and enforcements of certain employment laws. Now the Department of Labor and these two other federal agencies are talking to one another more than ever, and they are sharing information. So this is a reason to believe that enforcement is going to start going up. So when the National Labor Relations Board, when they come knocking regarding a potential violation of the National Labor Relations Act, if they see something suspicious regarding wage and hour issues, they may call up the DOL and say, hey, you might want to get over here and take a look. So that is a concern. And so my forecast, I think our collective forecast, is that cases are not going to continue to fall like they have over the last 7 years. Indeed, they may go up. So that's the national weather forecast. So there's some local issues which I think are very interesting. So Michigan is in what we call the Sixth Circuit, which is a group of states the whole country is split up into these regions. We're in what's called the Sixth Circuit for purposes of federal courts. So the Sixth Circuit is one of the three epicenters of wage and hour class actions and collective actions in the whole country. So forget about the national forecast for a minute. What's happening regionally? Real reason for concern that these class actions are landing in the Sixth Circuit, which includes Michigan. And as you know, class action is when it's not just one employee filing a lawsuit, it's a group of employees that file a collective action. And so the plaintiffs bar, the folks that are pursuing these cases, they have a very high success rate in the Sixth Circuit for getting these classes certified, which is a procedural step. So in one report that I read on this, they concluded that the plaintiffs bar is becoming more selective in seeking these class certifications, and they're concentrating their cases in magnet jurisdictions like the Sixth Circuit. So we are in an epicenter or a magnet of these potential class actions. So that's real reason to tune up on these issues. Furthermore, at the state level, the state of Michigan in 2019 launched a payroll fraud enforcement unit. They've created a website and a tip line. So the state of Michigan is really reaching out to workers to report misclassification issues and other wage and hour problems. The Attorney General's office in 2019, in a press report, said that most complaints that they receive involve misclassification of workers. So yet just another reason to really tune in to this issue of misclassification at your work. So that's the weather report. Now, I'm not going to go into great detail about this, but I at least want to give you a little punch list here of the areas where employers tend to make mistakes in and get involved in what I call an FLSA storm, to torture the metaphor. So number one is that employers misclassify workers as independent contractors. We've talked about that. You determine whether you classified someone properly, doing an economic realities test. We're going to get back to that. Sometimes employers misclassify employees as exempt from the minimum wage and overtime rules when in fact they are not exempt. And we've got to warn you, these rules can be tricky. They can be tricky even for experienced employment lawyers. The standards change. The standards are not always as clear cut as we would like. So there's some judgment calls involved here. If you fail to keep proper records, you can also get dinged by the Department of Labor or the state of Michigan. And then finally, another place where we see errors and where I've seen errors the most is when an employer fails to pay for all hours that the employee worked. So that might be not paying for travel time between job sites during the workday. It might be not paying for travel time to the first job site after an employee performs some work from home. We could probably spend an hour on that issue alone, but I just want to flag it for you. And that if you give an employee a meal break that is unpaid, but you do not relieve them from all their duties, so they're at their desk and they're still working during an unpaid lunch hour, that can be a violation. I've had a couple of those. And frankly, that usually happens when the employer doesn't even know that the employee is doing this and finds out later the hard way when the DOL comes knocking. So those are some common issues. Now, this is the hot topics portion, so I'm winding down on my portion. But this is what I call the storm watch, or what to keep an eye on looking into the future. So we think there's going to be an increased attention on misclassification of gig economy workers. And now we hear this term gig economy all the time, and gig worker. And frankly, there's no real definition of that. I think the closest we can get is the Bureau of Labor Statistics says a gig worker is someone who works on a single project or task, often through the digital marketplace, on demand. So the classic example of this would be your Uber or Lyft driver, and there's many others. I was very interested to see this, that Pew Research, they looked at the gig economy and they concluded that 16% of adults have earned money through the online gig platform. I personally was very surprised to see the number that high, but that's why this is going to be a real issue, especially in light of the changes that we're going to talk about in a minute regarding how to classify workers. And the DOL has, the Department of Labor, the Secretary of Labor has already told us that he thinks a lot of these gig workers should be classified as employees. And when I wrote these slides on Monday, I put this slide in that in 2022, we're likely to see new regulations on classifications of the economic realities test, which will definitely affect, or we think will affect gig workers. So that was on Monday, and I wrote the slide and it said, stay tuned. Well, this just in, the DOL yesterday announced that it's proposing a new classification rule for independent contractors versus employees. It's going to be officially published tomorrow. That's going to be followed by a 45-day public comment period. And then we expect at that point the DOL will either issue the rule as is, it might alter the proposed rule depending on what kind of feedback they get during this public comment period. Okay, that's a sound effect that was supposed to be in when it was this just in. All right, so this is the change in the rule, or I shouldn't say the change in the rule. This is what the DOL is proposing to change. And I'm not going to spend a lot of time on this. I just want you to be aware. Under the current way to classify a worker, according to the DOL, you apply what's called the economic realities test. And there are 6 factors. Now, under the current rule, the first 2 factors are called core factors, and they are automatically weighted more than the other factors. So those factors, again, are control over the manner in which the work is performed. So basically, if the employee controls the work, it tends to make the person an independent contractor. If the employer controls the manner in which the work is done, that weighs in favor of the person being an employee. So then there's also the worker's opportunity for profit or loss, the worker's investment in equipment and materials, how skilled the work is, the degree of the permanence of the relationship. Again, the more temporary it is, the more it tends to look like an independent contractor relationship as opposed to an employer-employee relationship, and whether the work is integral to the employer's business, which I've had cases where that is the most important factor. And basically, so if you're a house painting company and you hire workers to paint houses, the DOL is going to say, well, they're doing the work that is integral to your house painting business. They're probably an employee, as opposed to if you're a house painting company and you hire someone to pave the driveway at your bricks and mortar store, paving is not integral to your business. So that would look more like an independent contractor. So that's the current test. Now, the new proposed test is largely the same. However, those first 2 factors are no longer core factors. There's no automatic weighting of those first 2 factors more than others. Under the old rule, in some cases, those first 2 factors were dispositive, meaning kind of the whole shooting match was over once those 2 factors were established. Now we're going back to a former interpretation of this rule in which there's no pre-weighting of these factors, and the DOL is going to look at the totality of the circumstances to determine what's the economic reality here. Is this are the economic realities that this worker is an employee or that they're an independent contractor? So if this proposed rule is adopted as is, the punchline is that it's going to be more difficult for some workers to be properly classified as independent contractors. So that's the news. That's your weather report from me. I'm going to turn it over to Tony, who is going to talk about something you're probably very interested in and have heard about before, and that is some anticipated changes to the minimum wage in Michigan and some related changes to paid sick leave.